My name is Bruce Stanton. I've been a mobile home attorney since the early 19 to mid 1980s. I lived in a mobile home when I was in high school, actually, in Morgan Hill, California. So, sort of remembering those days, I can certainly uh, commiserate or identify with the mobile home lifestyle. And I've been representing mobile homeowners throughout California since the mid 1980s. First thing that we typically do on these town halls is I briefly review the status of legislation. Since it's now going toward mid-November, the 2024 legislative session has been completed. All the bills that were passed into law have been signed by the governor and chaptered. And we're already beginning to look at next year's legislative agenda. So I'm going to review very quickly a few of those bills, the sort of final status of those bills. And then I have a number of pre-submitted questions that I'll go through, and then we'll have plenty of time, I would believe, for any questions to be asked online. With respect to those questions, I would say this: the purpose of this call is to try to provide, basic and general information about the mobile home residency law, primarily, to some degree, perhaps Title 25 and the California Health and Safety Code, which is called the California Mobile Home Parks Act. We're not going to be able to get into real specific, long, detailed fact patterns or talk about ongoing cases. There is going to be one piece of litigation that I am going to talk about because there have been questions posed about it, and that's going to be the status of the park owner's challenge to AB 2782, and specifically that part of AB 2782 that talks about the long-term lease exemption from local rent stabilization. So I am going to give an update on that case. So let's launch into a brief review of the GSMOL sponsored bills in the 2024 legislative session. And there were three of them that GSMOL was involved with as sponsor, two of which moved forward. And there were a few other bills that we were significantly involved in, even though GSMOL was not exactly was not listed as a sponsor, and formally speaking was not a sponsor of those bills. First one I want to talk about is SB 1408. SB 1408 by Senator Roth dealt with the issue of work vehicles being parked in a resident or homeowner's carport. And the bill was signed into law and chaptered by the governor after passing both houses. And the bill prohibits management from removing vehicles used or required by the homeowner for work or employment just because they advertise trade or services on the vehicle. So, we've had these situations that I've encountered in the past where management said you can't park any vehicle in your carport that has advertising on the side of it. That's a work vehicle. This bill would say no. This bill does in fact say no, there's nothing wrong with that. Plenty of people have work-related vehicles that have advertising on them for whatever reason. And the real thing that management's solving for here, of course, is the prohibition about conducting businesses in the park. And the idea that if you have a vehicle with advertising on it, somehow ipso facto, that's, tantamount to conducting a business in the park. And that's simply, of course, not true. So this bill clarifies that. As well, it says that if the vehicle, because of its size, is intruding into the park roadways or otherwise poses a significant danger, well, then, of course, management would be well within its rights to require the removal. And that would be a whole different issue. But that's what SB 1408 accomplishes, and it amends the mobile home residency law in order to do that. And that's at Civil Code 798.2. 28.5. The other bill I wanted to mention that GSMOL sponsored was AB 2022 by Assembly Member Addis, and that is a bill that would have required the park owner to adopt an emergency preparedness plan that included attesting under penalty of perjury compliance with certain things like fire hydrant testing, or emergency access, ingress or egress from the park, emergency routes. That bill passed through both houses, but was vetoed by the governor. So that legislation was not successful. It will be determined by the GSMOL Legislative Action Team whether or not to revisit that based upon perhaps the governor's objections. I don't have those reasons in front of me today. I'm not really sure why the bill was vetoed, as I've been wrapped up with some other issues the last few weeks that have taken up a lot of my time. But I'm sure we will be revisiting, the reasons for the veto to see whether or not the bill could be brought back. The third bill was legislation that continued legislation from 2023 by Assemblyman Al Muratsuchi, who is down in the Torrance, California area of Southern California. And that is the bill that is entitled the Mobile Home Affordability Act, that would place rent regulations in areas which otherwise do not have a rent stabilization ordinance currently. That bill was sort of the second generation of a bill in the prior year, which was AB 1035. That bill did not advance. It didn't advance out of committee. It will be reconsidered. It's an issue that GSMOL is still working on. But one of the reasons that the bill hasn't advanced is the presence of litigation. There was a previously chaptered provision that became a part of the mobile home residency law that states if a park is located in more than one local jurisdiction, in other words, if the park is one half in one city and one half in another city, that there would be rent caps or rent regulations that would attach to that park. To the best of my knowledge, that only applies to one park in the state, possibly two, but as far as I'm sure of, it only applies to one park in Southern California. That bill has, or the result of that bill, the mobile home residency law provision that was enacted pursuant to that bill, has been challenged, and that court action is currently pending. And my understanding is that committee chair has been reluctant to move the Muratsuchi bill forward until more is known about how that litigation is going to turn out, because to some degree, it's the same subject matter, which is imposing some kind of rent regulation or rent caps in the mobile home residency law. And that's something that the MRL currently does not address. And by the way, I'll be referring today, as I am always doing, to a number of provisions from the California mobile home residency law, which we call the MRL. And that's found, for anybody who's not familiar with it, at California Civil Code 798 et sequitur. Starts in 798 and goes through 798.88 or 87, I believe. And that's the law that's really your Bible, because it governs all of the basic rights and responsibilities between management and homeowners. There's another body of law in the California Health and Safety Code that deals with more technical issues relating to codes and standards. And there are regulations that have been adopted pursuant to the Health and Safety Code in Title 25 of the California Code of Regulations. So to summarize, we basically have a Bible that has two parts. As the former HCD attorney used to always tell me, the Old Testament is the Health and Safety Code and Title 25. The New Testament is the mobile home residency law. And it's the mobile home residency law that basically has grown up over the last few decades pursuant to the efforts of GSMOL, which for the most part has been responsible for passage of almost every provision in the mobile home residency law. So those were the three bills that GSMOL actually sponsored. A couple of other bills of note. One was SB 1190 by Senator John Laird. This was passed, and GSMOL was involved in the process of the bill's gestation and passage. This is a bill that governs the ability or allows the ability of residents to install solar energy, and it prohibits any covenant restriction, rule, or regulation that would absolutely ban altogether residents from accessing solar in connection with anything that would, power or feed energy to their homes. There is an exception to it, which is that the bill as passed does not apply to any master metered mobile home park, which means it doesn't apply to a park which has sub-meters for gas or electric, where the park owner bills the residents for the energy and has taken over responsibility from the serving utility or maintaining the utility system. That's obviously a big exception because there are many, many parks within the state that do sub-meter gas and electric. However, there are issues involved with that required more further investigation and consideration in terms of the power grid and how park owners' energy efficiency and capabilities might be affected as if residents in such a park started installing solar. So with the idea that we need to investigate that further, the bill was passed with that notable exception. And the other thing I'll mention is a number of master metered parks where the park is billing for energy is going to be dwindling due to the California Public Utilities Commission program, what's called the Line Extension Program, that allows parks to queue up, get in line, and seek participation in the program where the old energy systems will be abandoned and new gas and electric systems will be created in the park. And when the new system is ready, there'll be a cutover where the old system is simply abandoned in the ground and the new system is energized. And the important thing about that program, which took the better part of a decade to put into play, pursuant to hearings and workshops that happened in San Francisco at the California Public Utilities Commission, the important thing is the cost of those upgraded utility systems will not be borne solely by the park owner or by the residents. They will be borne by all of the ratepayers in the state of California, which means everybody's utility bills go up a few cents to cover the cost of the upgrade. So this bill, importantly, removes the absolute ban and absolute restriction on residents' ability to install solar. And we'll just see how things develop, with the topic, and there may be further legislation in the future. And the only other bill I wanted to mention was AB 2247 by Assemblymember Wallace. And that's a provision that extended, as it was also signed by the governor, it extended the Mobile Home Parks Act, or the MPA, inspection program that's conducted by Department of Housing and Community Development. That's HCD. Currently, that program provides that once every so many years, and the idea is, as the bill was originally passed back in the early 1990s, was to have a program where every park in the state would be inspected by HCD every 7 to 10 years. And there's a fee that's paid by mobile home residents. To defer part of that, the park owner has to pay a fee to the state for that. And there was an audit of the program a few years ago. The new HCD leadership committed to really, spiffing and buffing up the program, making it more efficient, and implementing it more effectively. I think that's been happening, and I'm sure there's always improvement that's needed. But this bill very importantly extended the sunset date of the program because it was originally, as the bill existed, supposed to end on January 1st of 2025. It was extended another 5 years to January 1st of 2030. So that program is going to be ongoing. One other important addition, when the department is inspecting and finding violations on residents' home sites, which could happen, that not only the common areas are going to be inspected, but the entire park will be inspected. And there could very well be violations on resident home sites that would be cited. Well, this bill provides that the department will provide a list of available rehab or repair programs, in other words, sources that homeowners can investigate or access in order to make required repairs, so that they're not, completely in the dark. With the economic problems that occurred during the dot-com crash and also during COVID, a lot of grant programs either were suspended or went away. So it's important that information be given to homeowners when those kind of repairs are needed. So those are the main bills that I wanted to talk about today. And of course, the GSMOL legislative program is always a vital part of what the organization does on an annual basis. And I've been significantly involved in that process in terms of, drafting the legislation, wordsmithing it. We do a lot of work with committee council, with the committee chairs, and with staff on these bills. There will be updates in the future regarding the 2025 legislation. GSMOL always sponsors bills every session, and typically the response to certain pervasive and repeating problems is going to be the reason for legislation when it comes up, because we can't just make this stuff up. We can't just say, well, it'd be nice to have a bill for this, even if there's no problem in evidence. There has to be evidence of the issue. There has to be some reason for moving forward. And that will always be the case. And that's why we always will be reaching out to you all, reaching out to those of you who are actually, living in the lifestyle out in the field. What kind of issues are you experiencing? What kind of problems do we see that are repeating or more pervasive that might require a legislative fix? Not everything requires a legislative fix, but many things do. And that's why we have the mobile home residency law. It is a consumer protection law that cannot be waived, even if you wanted to waive it. And that means that, if the law says that you're entitled to a 90-day notice of a rent increase, you can't tell the park owner, well, you only need to give me 30 days, because that's all I really need. The law would say, you don't know what you're doing. This is a consumer protection law. Nobody can waive it. It is required to be enforced exactly the way that it's written. Okay. With that, I'm going to go through the questions that I've received in advance. And I think we'll be able to get through these pretty quickly so that by 11 o'clock or maybe even earlier, we can open up to questions from the audience, which has now grown to 164 participants. So that's a whopping number. That's really great to see. So we have a question about the procedures for selling park-size model homes, along with the issues that arise. Since park model homes are registered as RVs, are there differences in the process? So just a bit of background. There is a type of manufactured home that's called a park model. It's a very, and these are new homes that are being produced. They look very nice. In every way, they look like a typical mobile or manufactured home. The only difference is they're smaller and they don't meet the definition of a mobile home found in the civil code according to their size. And there is a definition in the civil code that actually then refers to a section of the health and safety code. We're looking at a certain number of square footage, actually, which is sort of the dividing line between mobile manufactured home and a park model. So there are park models being produced, brand new, being moved into parks. The question is, are they treated the same as mobile homes? Now, the procedure for selling them is not different at all. There's no different procedure that I know of. The only issue is, are they entitled to the same protections under the mobile home residency law? And the answer is found in the definition of a mobile home, which is found in Civil Code 798.3. And in that section, it says that a recreational vehicle, which is really what a park model technically is classified as, is entitled to all of the same protections as a mobile home, provided that it's been in the park for 9 or occupied a site in the park for 9 consecutive months or longer. So if a park model is moved into a park on a space, hooked up, occupied, and somebody lives there for 9 or more consecutive months, then that park model is treated just the same as a mobile home for all purposes except one. And the sole exception is resale. A park can require, contrary to the law that applies to a more conventional mobile or manufactured home, a park owner could require that a park model be removed from the site as a condition of resale. In other words, the park management could say, we're not going to allow the park model to be sold in place. If you're going to sell it, you have to move it. And that's the same for any kind of an RV. As long as the RV is there, including a park model, all the other provisions of the mobile home residency law will protect that homeowner. Anything to do with rules and regulations and utilities and resale and ability to have free speech and meet in the park, all those other provisions apply. But when the time comes to sell, at its election, the park could require that home to be removed. They don't have to, of course, it's up to the park. And one would hope that if it's a pretty new park model, which is in really good condition, and the park allowed it to be there once upon a time, one would hope that they'd allow it to stay there. But the park owner could decide, I don't want park models any longer. So you have to move it out if you're going to sell it. That's a huge issue. And it's something that when someone is thinking about purchasing a mobile or manufactured home, they should be aware of. Until this law is changed, until specific legislation addressing park homes or park model homes is actually passed into law, that's the way the law reads. Otherwise, there's no difference in the procedure. You know, the procedure for selling, for noticing the sale, for repairs and upgrades, which we're going to talk more about here in a few minutes. All of that's the same, and there should be no difference. Next question. Manager has informed us the air conditioning will be turned off in our clubhouse at 4 p.m. every day. Can they do this when we have a lot of activities in the evening? Well, the section of the mobile home residency law that is applicable here is Civil Code 798.24. That section deals with the common areas of the park, and a clubhouse is part of the common area facilities. And that section says each common area facility shall be open or available to residents at all reasonable hours with the hours posted. Being open or available, as we sort of segue to this question, certainly I believe means that it has to be livable or occupiable, I guess is the word I want to use. If we're talking about the height of summer in July and August in a place that like maybe Paso Robles, that is very, very hot in the summer. If management says we're turning off the air at 4 o'clock, we might construe that to mean the clubhouse can't, nobody can really be in there any longer. It's just going to be too hot. And especially if there's no window shading, if you have north south or as opposed to east west, that could affect it. But if turning off the air or turning off heat, for example, if we're talking about a park, up in Truckee by Lake Tahoe, if that's going to affect the ability of people to access and use the common area facility, then I would say that decision to stop using air or heat is a violation or could be a violation of Civil Code 798.24, because then the clubhouse is no longer really open or available at all reasonable hours, is it? I mean, you could say it's open, but if going in there is like going into a meat locker because of the cold, or going into a sweat box because there's no air conditioning in the summer, then for all intents and purposes, it might as well be closed. So that would be my opinion about that question. And I would say residents in such a situation should protest that. Get a petition together, book a meeting with park management as the mobile home residency law allows. And that's in the Article 5 provisions. There's a provision that we just recently actually updated. Management meetings with residents, that's 798.53 of your MRL. Book a meeting. Complain, tell them why you believe the air should be left on for longer, especially in the warmer months. 4 p.m. is almost the height of the heat. Probably between 4 and 6 p.m. is when it's the hottest. So there may be no reasonable basis for shutting off heat or air other than saving money. And the park owner can't choose to save money in a way that makes the facility difficult or impossible to access. All right, we'll move on. How much can a park owner require a homeowner to fix on the home site or space prior to putting a home on the market? And I think the question really is, it has two parts. When somebody is selling their home, what is management's, what's the scope and authority of management's ability to require repairs or upgrades to the home itself? And sometimes a separate question, oftentimes a separate question, what is the authority or ability of management to require repairs to the physical space, the exterior space? So let me just address both those. The first part of that, the repairs to the home itself, are governed in Article 7 of the Mobile Home Residency Law. There's a very detailed provision found in Civil Code 798.73.5. And that's the home upgrades on resale provision. In the industry, we call any kind of resale repairs upgrades often. That section provides that the park owner can require repairs or upgrades to the exterior of the home if there are violations that if there are code violations typically of part of that Old Testament that I mentioned, Title 25, or the Health and Safety Code, or if there are violations of rules and regulations. And of course, as we know, rules and regulations must be reasonable. And so that's always a modifying word when any rule or regulation is sought to be enforced. So when we look at the upgrade section, again, we note the repair or improvement is either required by state or local law, i.e. a code violation or the rules, and it relates to the exterior of the home, and it must relate to the home or an accessory structure, shed, deck, enclosed porch room, anything like that is an accessory structure. It's notable that this section does not include the interior of the home. The park owner has no jurisdiction over the interior of your home. Park owner cannot require that the dishwasher be replaced or that, dry rotted flooring around a toilet be replaced. It has to relate to the exterior. Common upgrades or repairs, taking grease and oil off a driveway, fixing or replacing dented awning posts in the carport, which happens frequently, right? When you're backing out, pulling the car in, and over time, those things get dinged up. Replacing worn or ripped carpeting on steps leading up to the back door, carport, porch, or to the front deck. Replacing dry rotted, out of code steps or porches or decks. Handrails are a key item that oftentimes is flagged because handrails either get loose or sometimes, for whatever reason, somebody's got steps and there's no handrail at all. There's very specific Title 25 provisions that require steps to be constructed in a very certain way. The risers of the steps need to be of a certain height and dimension, and handrails are also described. That's going to be one area where, for example, if the state of California, HCD, came out to inspect, during one of its park-wide inspections, they'd flag that, and the homeowner would need to repair that item. So those are some examples of exterior. A shed would be another one. If the shed is just dilapidated, it's fallen apart. Landscaping is obviously a common one. If you have dead landscaping or the absence of landscaping, then that could also be flagged as a repair or upgrade. But as we begin to talk about the space, there is an important limitation. Years ago, before this section I'm about to talk about was passed, we had some park owners. It's a little laughable to hear now, given our drought conditions in California over the last number of years. But back in the 1990s, there were actually some park owners that were requiring a selling homeowner to install sod and sprinkler systems on the space before they could sell the home. And in response to that, and in response to demands that trees be removed, sometimes at the cost of even thousands of dollars, we got into law a provision that addresses the repair of the space. And that's also found in Article 7. It's at the very, very end of Article 7, which is the resale provisions of the mobile home residency law. 798.83 is a very short, basically one sentence provision. As I recall, that GSMOL, we just wrote this language word for word. And it provides that when a home is being sold, the management shall not require repairs or improvements to the park space or property unless there's damage or a condition caused by the intentional action or negligence of the homeowner. So if the homeowner has been, digging on the property and, a sinkhole develops or something, under that hypothetical, the homeowner could be responsible for that. But otherwise, the park cannot require repairs to the space. They can't say you have to regrade the space. They can't, again, unless the homeowner caused the problem. But if water runoff, something, the course of nature over time has changed condition of the space, the park owner would be responsible for that regrading if the homeowner had no responsibility for the problem. And the most common way that this section comes into play, in my experience, is with tree removal. Management cannot say, well, there's 3 palm trees on the lot. We don't like palm trees anymore. You have to remove them. This section would say, no, the palm trees are fixtures. They're part of the land. You can't dig up the palm trees and take them with you when you sell the home. The rental agreements that you sign with the park are going to say, those are fixtures. They're part of the land. We own them. Well, they can't require repairs to the space that would result in many, many hundreds or even thousands of dollars for tree removal. So that's the breakdown. Resale upgrades and repairs with respect to the home itself and with respect to the space. And as a related question, if structures such as carport stairs are currently grandfathered in based on the age of the home, can the park require the stairs to be brought up to current building code? Well, in that case, the answer is yes, because it's one thing to be grandfathered in if you have lattice on the carport or some kind of panels. There are some parks where people have been allowed over the years to erect or affix these corrugated roofing panels to the side of the carport for sun shading purpose. Well, my argument would be the park can't just arbitrarily say, well, we don't like those anymore, you have to remove those. Those would probably be grandfathered in if when they were installed, they were approved and the rules didn't prohibit it. But code violations are different. You know, when you're selling the home, it must comply with current law. And so if handrails or steps don't comply with current law, it's my opinion the park is well within its ability to require that those be brought up to code. Can the park owner block the sale of an older home? Only under limited circumstances. And I think I have another question about that, but I'll just address that now. Residents are obviously concerned if they want to sell, they have an older home. Can the park say, this house is too old, we don't want it in our park anymore, you're going to have to move it as a condition of sale? And if they say that, it probably means the home is unsellable, because it's not very often anybody can sell a mobile or manufactured home to somebody who's going to move it out of the park and take it someplace else. I'm not saying it never happens, but it would be extremely, extremely rare. So way back when Governor Brown was governor, and when he had hair, and when Linda Ronstadt was his girlfriend, GSMOL got passed into law a provision which became known as the Mobile Home Resale Eviction Protection Act. And it relates to a very important section of the MRL, which precedes the one we just talked about. We just talked about Civil Code 798.73.5, which is the mobile home upgrade or resale provision. The prior provision in sequence is 798.73, removal of mobile home upon sale to third party. Study that provision carefully, because you will find when you read it that it contains a very significant protection. Before this current language was passed into law, there used to be a rule called the 17-year rule in the MRL that basically said, if a mobile home is more than 17 years of age, the park owner can require it to be removed on resale. The idea just being, and I'm not sure why they picked 17, but the idea pretty much being, you know, if it's 17 years old, it's probably too old. It's outlived its useful, depreciable life. Well, although you will see reference to 17 years still in subsections of this provision, the real key now is found in 798.73D, as in David. That section says, because for most homes, the other sections above it are basically saying only if it doesn't meet code, the park could require removal. But the real key is subsection D. Removal could happen if the home is significantly run down or in disrepair. That's really the key provision, if you will, as determined by its general condition and acceptability to health and safety of occupants and the public, exclusive of its age. Meaning, we're not talking about the 17-year rule any longer. Management has to use reasonable discretion in determining the condition and bears the burden of demonstrating that it is significantly run down or in disrepair. Folks, in my experience, and I've actually litigated this issue in one pretty significant trial probably 15 years ago, it's very difficult for a park owner to meet this burden of proof. Basically, there'd have to be, you know, an inspection of the entire home. Maybe you've got a situation where the home has, you know, outdated aluminum wiring and it's dangerous, and there's no way to fix it. But if there's any way to repair the issues, any way at all, I think that management would really have a tough time arguing significant rundown, condition, or disrepair. And look, that's going to be happening more and more as these homes that have been in the park for decades get older and older. We get that. There are some situations where it may very well be, um, justified. But in my experience, it's rarely ever used. And again, that burden of proof is heavy on the park owner. So it's very important, obviously, for anyone selling a home that the mobile home or manufactured home be sold in place. If it has to be moved, it has virtually no value. You gotta, hope a contractor who wants to use it as a headquarters, building something out in Utah, wants it for some reason. The value is really intrinsic to being in a park surrounded by improvements, all the common areas, the roads, the utility hookups. And it's very, very expensive, obviously, to move a manufactured mobile home, especially if it's in 2 or 3 sections. You got to separate it, truck it out of the park, the travel distance to another location where a space might be available, and then reset it. And in some cases, I think homes are probably so old that they could never stand the journey, frankly, and never, once they're broken apart, be very effectively married back together again. So this is a very important section that protects homeowners, in my experience, in virtually all situations I've ever seen, from the park requiring that the home be moved out as a condition of sale. Next question comes from an agent, or I guess somebody, maybe this is not one of the agent questions, but it's related to that. Again, we have a lot of resale questions today, which is, I think, significant. It tells us what really is on folks' minds a lot these days. This is a situation where there's a park that has current litigation happening, and the real estate agent has tried to pre-qualify potential buyers and been told by a lender, we're not going to do that right now because of the presence of litigation. And I'm not sure that I can really fully answer that question. I don't represent lenders. I'm not real keyed into what kind of lender requirements or indicators they might look at in giving loans. But I could well imagine, however, that if there is a question about something in that park, there's some kind of litigation ongoing where it's questionable whether rents are going to be raised or not, something that could affect the ability of the borrower to timely pay their mortgage, and the lender believes that's a risk. I think it's probably well within their prerogative to say, we're not going to pre-qualify anybody. You're going to have to wait until this litigation resolves itself, and until we are comfortable lending in that community. The question goes on, what can be done about it? Well, I guess hopefully the thing that would happen is the litigation will be resolved, right? And any question about whether or not rent might be raised or whether something else is going to happen in the park, maybe a park closure issue could be in litigation. Obviously, a lender doesn't want to lend money to somebody buying a home if the park might close, and then the lender could lose their collateral, the security for their loan. I would say the thing to be done is, first of all, just try to explain as much as you can to the lender. Have the agent explain to the lender exactly what's going on. Maybe the lender is overemphasizing the risk, and otherwise, you may have to wait until the litigation resolves. It's really up to the lender, I think, to make that decision. Second question from this person was, if somebody in a park, whoever it might be, a manager, other residents, approaches a potential buyer of yours with negative information or false information about what's the park status or something that's happening in the park, is that actionable? Well, it could be. I mean, if a resident takes it upon themselves to insert themselves into somebody else's transaction, I would certainly say that could be problematic for that person, because I'm not sure what their motivation would be to try to influence whether one of their neighbors could sell their home. Certainly, if they are giving false information to a buyer and that buyer acts upon that information to say, I think I'm going to want to back out of this transaction. And if the seller lost the sale, the person who inserted themselves and gave that false information could be liable for what's called interference with prospective economic advantage, meaning the seller would presumably have sold the home but for this information, poisoning or tainting the sale. What can be done about it? Well, I mean, obviously the agent should want to set the record straight. If you're dealing with the other side's agent and suddenly the buyer's agent says, look, my client was just in the park to take another look at the house and somebody came up and started telling him all this stuff. Is this true? I mean, here's an example. Did you know that, 7 sex offenders live on your street? Or something, especially if it's completely false. Well, the agent for the seller would certainly want to try to set the record straight and request a retraction of that information, and also tell or try to find out who's saying this and get him to cease and desist. If the manager is the one who, if any park management is, feeding false or inaccurate information to potential buyers, I think we have to question, why would that be happening? What would be the reason for that? And I think most homeowners would probably immediately go to the conclusion, management does not want me to sell my house. They are intentionally trying to discourage buyers or get buyers to even cancel existing escrows or transactions based upon false information. That is obviously even more actionable, I believe, because now you've got motive, you've got opportunity, and that might feed into a park owner's desire to, grind down a homeowner who's trying to sell to the point where the homeowner just gives up and says, I'm just going to walk away from my house. Or then management comes in and says, hey, we'll buy your house for $10,000, basically a fire sale price. No buyer wants to be ground down to that position, and certainly the law would not countenance that. So in that kind of situation, it might be that the buyer needs legal representation. They need somebody to step in and either put a stop to it or, make a demand that, unless it does stop, if a sale is lost, especially a pending sale is lost, that management could be liable for causing that sale to be lost, interfering with the prospective economic advantage. And then I speak in terms of statements or information that's false or misleading and designed to interfere with the transaction. Question came from a park where new rules and regulations are being proposed, and there's a provision toward the end which is called estoppel certificate. Upon park's request, homeowner must within 10 days execute, acknowledge, and deliver to the owner a fully executed estoppel certificate. Failure to do so within 10 days is a violation of the rules and the tenancy could be terminated. So the question is, what is this? And is this proper? An estoppel certificate is, in my experience, very rarely used, or very rarely does it become relevant. It's essentially a statement that the resident, the homeowner, is not aware of any pending litigation. There's no claims that the resident has against the park owner. They're not aware of any issues in connection with their tenancy, essentially. And estoppel certificates really are only used if the park owner is selling the park, and the buyer who's buying the park wants to be sure they're not buying a lawsuit. They're not buying a park that has a bunch of, problems and claims that are pending, because then the new owner of the park is stepping into the shoes of the old owner, and suddenly they're faced with all these, ongoing issues, which could include court litigation. So the estoppel certificate, which is used in all kinds of housing, it's used very commonly in apartment housing as well, perhaps even condominium associations, is something that the buyer of the park, the prospective buyer of the park, I'm talking about the whole park, not just one home, of the entire park, would say, I want all of your residents to confirm what you, the selling park owner, are telling me, which is you're not in any litigation with them, you don't have any problems or claims. And then the homeowner just fills out, it's usually like a pre-printed sheet, signs it, and turns it back in. There's no real downside to doing this for the homeowner unless there's an issue regarding them having a claim against the park and they fail to disclose it. If they don't fill the estoppel certificate out accurately, maybe there could be a cause of action against them for lying about, not having a claim. Can a park owner get away with, putting this in the rule? If you don't turn it back within 10 days, it's a rule violation and we could terminate your tenancy. Well, sure, they could put it in the rule. There's nothing wrong with putting it in there. Is it enforceable, however? I would say this. If a park owner went into court to evict a homeowner and this was the sole basis, you didn't give us an estoppel certificate within 10 days, you gave it 12 days or 15 days, or maybe you didn't even give it at all, I don't think a park owner would ever win that eviction, to be honest with you. Maybe only if they lost the sale of their park because the homeowner or some group of homeowners didn't turn those back in. Again, I've never seen that issue come to a head like that. It's kind of a scary sounding thing. Oh, geez, what is this? And, could they really terminate us? I mean, it's possible, but I'd say very doubtful. Next question was getting an update, as I have just a few more to go through, getting an update on this litigation that I mentioned before, I think briefly. And this is the park owner attack. The WMA, Western Manufactured Park Owners Association, has filed a lawsuit against the governor challenging Assembly Bill 2782, which was passed back in the 2020 COVID legislative year. AB 2782 did two important things. Number one, it updated, amended, and strengthened the park the protections regarding park purchases and how that would all happen with respect to residents maybe purchasing a park where the park was closing, and most significantly upgraded protections related to park closure and how a park owner needs to proceed in terms of the process of the closure, and also the last resort or mitigation measure, which is buying out the residents at fair market value if you're going to close the park. So that's one whole provision. And that started out to actually be a separate piece of legislation before COVID hit. That part of it was combined with another part, which has become the real focus of this WMA lawsuit, and that is the sunsetting or end of the long-term lease exemption from local rent control or rent stabilization. Since the late 1980s, Civil Code 798.17 has contained a provision that says any long-term lease which exceeds 12 months is exempt from local rent stabilization. And there's no ending to that, as the law was worded prior to AB 2782. In the 2020 year, GSMOL passed this assembly bill through both houses, and the governor signed it, which basically says any new long-term lease which exceeds 12 months signed after February 13th of 2020 will not be exempt. And all leases, whenever they've been signed, will lose the exemption as of January 1st, 2025, which is what, about 1 month and 20 days away. So if nothing else happens, as of January 1st, 2025, all long-term leases that exceed 12 months will no longer be exempt from local rent stabilization. Obviously, a very important provision for homeowners who are in that situation. WMA, the Park Owner Trade Association, has filed this lawsuit objecting to AB 2782, the end of the long-term lease exemption, saying it's unconstitutional, that you cannot interfere with existing contracts. And they cite not only provisions of California law, but United States constitutional provisions in support of that argument. The lawsuit was filed some time ago, but most recently, the activity that is of most note is because essentially when the suit was filed, the governor filed what's called a demurrer to it. They said, this doesn't even state a proper cause of action. We're going to knock this case out of the box right away. Part of it was knocked out, but part of it remained. And the court said there is a valid cause of action which can proceed to trial. Well, as the case has been sort of going along through its process, the park owner now has filed a motion for an injunction. They're seeking an injunction order from the court that would stop January 1st, 2025 happening in another few weeks. That hearing was scheduled for last Tuesday, the 7th of November. It has been continued to November 21st, and that's in the Sacramento County Superior Court. So that's going to be a very important hearing because the Park Trade Association, the Park Owner Trade Association, WMA, they have to prove irreparable injury. To get an injunction, you have to prove that I will be irreparably injured unless the court steps in to stop this law from taking effect. I've seen the briefing on the issue. The Attorney General has, filed opposition to this. It's very lengthy, well-supported, well-thought-out opposition. The Park Owner Association has hired a law firm that probably is expert in constitutional issues. It's going to be a very interesting argument. Again, that will occur on November 21st. If the injunction is granted, then the January 1st, 2025 exemption for all existing agreements, presumably that's not going to happen. That's going to be put on hold until the lawsuit goes to trial, presumably sometime in 2025. And the court renders a decision on the merits for the entire claim. If the injunction is denied, then on January 1st, 2025, every long-term lease, i.e. leases that exceed 12 months in California, will no longer be exempt from local rent stabilization. And if there is a local rent regulation, that regulation will apply to the financial aspects of the rental agreement. Now, it's important to understand, this doesn't blow up the whole lease. It only affects the rental amount provisions. So all other provisions of the contract will be enforceable. If you signed a lease with an arbitration clause, that's going to be enforceable. If you have pet agreements in there, or pool agreements, RV storage agreements, the rules and regulations of the park, none of that is going to be affected except with respect to the rent amounts. The rent amounts will have to yield to the local rent regulation. So that's an update on that litigation. So just a couple more questions. If a home is not cited by HCD in a park-wide inspection for violations, so that HCD didn't say, you've got a setback violation or your shed has to move, can the park owner require that? If you're not cited for any kind of Title 25 violation, in other words, can the park owner say, well, even though HCD didn't cite it, you got to, move your house, or you got to move your shed or you have to take down your lattice. I mean, I would say this. If the park owner is trying to enforce the law, Title 25, that's wrong because the park owner doesn't have jurisdiction to enforce the law. A lot of management or park owners may think they do, but they really don't. That's the state's prerogative unless a local jurisdiction has taken over local enforcement agency jurisdiction. And there are a number of them, about 75 cities and counties, I think, have taken that over. But otherwise, the state enforces Title 25, not the park. Now, the park might flag those and say, hey, we think this is a violation and let's get the state out here to confirm it. But if the states come out and they said, we don't see a violation here, the park owner can't say, well, we don't care what HCD founder said. We think there's a violation, so we're going to enforce it. That's not the way that works. So for code violations, I would say if HCD literally didn't find one, then the park owner can't allege one. However, there could be rules violations that don't affect the code. And for those, then the question is, lattice is a perfect example. A park owner says, okay, you have to take your lattice down. Well, what's the reason for that? There's no code that says you can't have lattice. Park owners have been recently kind of fixated on this, some park owners, and I'm not really sure why, but the rationale seems to be, we think it's a fire hazard. Well, that probably depends upon what the lattice is made of, but I can tell you in my own personal conversations with the field operations director of codes and standards of HCD, he tells me lattice is not presumed to be a fire hazard. If it's wood, if it's closer than 6 feet from another structure, it's not fire treated wood. Maybe it is for another reason, but just by itself, just because it's lattice, that's not a fire hazard. And until somebody produces authority to me to the contrary, that's going to remain my position. It's also true that if the lattice was there when somebody bought the home, it's grandfathered in. And if the park says, well, we changed the rule now, and now the rule is there's no lattice. Okay, well, if that's a reasonable rule that could be enforced, that might mean nobody can put lattice up from this point on. But you can't pass a rule that says no lattice, so everybody who has lattice has to take it down. If the lattice was already there, and if it was approved to be installed, it's grandfathered in. And that applies to any kind of other related issue that's not a code violation. So in my opinion, requiring that for an existing homeowner would be very problematic. I don't think you could do it. Requiring it at the time of resale might be another issue if there is now a rule that says you can't have lattice. But again, I'd be looking at it and saying, well, what's it going to cost somebody to take this down? And was it approved? And why are we saying it has to be removed? Is that a reasonable rule to just say, we don't like lattice anymore? I think I would question whether that's reasonable. And if management's requirements are outside of the MRL, would that be interference with resale and subject to legal action? Absolutely, because remember what we talked about earlier, 798.73.5 says exterior issues that are code violation or rules violations only. That's the only maneuvering area the park owner has to require resale upgrades. I've already answered a question, a more specific question that was asked about 798.73 requiring a home in rundown condition or disrepair to be removed. But a related question is, can a management company insist that homes that are being sold over a certain age must have a complete home inspection inside and out by somebody with a C47 contractor's license? And I would say absolutely not. Again, the park has no jurisdiction over the inside of the home. They cannot demand or require, you can't sell your home until the entire inside of the home is inspected. In my view, a park owner would have no reasonable basis for requiring that. They're not going to get sued by somebody who says, when I bought the home, the buyer or the seller told me the dishwasher worked and I found out it didn't work. The park has no liability for anything like that. I mean, I would say as well that, a C-47 license really would be germane to the exterior of the home, where the park does have um, jurisdiction. I would also say this: I would never advise any mobile home buyer to ever buy a home without getting an inspection. Okay, I think that would be a very risky assumption of risk proposition for a buyer. And I would also say that I think a smart agent will tell their clients, let's get an inspection before you even put this on the market. Because if there is an issue, we want to know about it now and let's fix it now so that we're not surprised by it, and wasting our time or incurring a bunch of costs that then we have to just jam in, while we're in escrow, and then maybe we don't have time to price the work out correctly and so forth. So in some ways, I look at this issue and say, well, I don't think a park can require that, but I also don't think it's smart for people not to do it. So, there you have that. Um, there was also a mention that a management company has interfered with sales by saying in a letter from an attorney, this is our land and the home has to be removed from the park. Well, okay, but that's not the issue. The issue is not whether it's their land. The issue, as I already have mentioned, is 798.73, substantially run down or in disrepair. Park owner has to prove that. If a management company buys homes in the park, can they raise the rent when they sell it? Absolutely, they can. When there's no local rent ordinance that I know of that controls rents when the park owner owns the home. That's not the purpose of the ordinance. The purpose of the ordinance is to protect real homeowners who are in the home, an immobile home, and an immobile home park. They're captive, they're trapped. If the rents are going up, either they have to pay them, or else maybe they lose their home. They can't just move down the road to another apartment complex like an apartment dweller can and find a cheaper rent. Mobile homes are not really mobile at all. They hardly ever move. So if the park owner buys the home, well, the park owner can raise the rent if they're going to resell it, because the ordinance doesn't apply to that transaction. And it doesn't matter if it's a new home or if they're taking over an existing home. The final two questions quickly: what's a storage contract and what's the implication of that in rent-controlled parks, especially for heirs? Very quickly, a storage agreement is something that is commonly required by park owners when somebody dies and the heirs come in and they say, we want to sell the home, which the mobile home residency law allows them to do. In that case, they have to have some kind of an agreement with the park, because they're not tenants, they're not homeowners, they're the heirs who inherited it, and they're just selling it in place. And so that's usually what a storage agreement, as we call it in the industry, is for. The storage agreement will define the terms and the obligations of the parties going forward in terms of keeping up the space, paying an amount of money every month that's not really rent, but it's going to be like a storage fee, because the park owner does not want to create a contract with the heirs. The heirs aren't the homeowners. They don't have a lease or a rental agreement with the heirs. So the storage agreement's a perfectly acceptable way to do that. Whether the rent can be increased depends upon the local ordinance. If there's no ordinance, then the rent can be increased when the heirs sell it. If there is an ordinance, you have to check the ordinance to see if somebody dies, does the ordinance say that the heirs are protected from that? In other words, that the rent can't be raised if somebody passes away. There are some ordinances that say that, some don't. And the ones who say that may also limit it to the rent only stays the same if one of the heirs qualifies for tenancy and then is able to move into the home. The final question that I got, which came from one of the agents, deals with communications with park attorneys. Is an agent permitted to respond directly to park attorneys when advocating for clients, and especially, quoting the MRL? This is apparently a situation where the attorney in question said, stop communicating with me, cease and desist, you're not a lawyer. I can pretty well guess probably who that attorney was, to be honest with you. I it's not, I don't represent real estate brokers and agents or salespersons or dealers per se. So I don't want to, on this particular town hall, say I'm here to start advising those professionals. But I can certainly opine on this, which is to say, there's nothing wrong, in my opinion, and you would always want to check with your supervising broker, but there's nothing wrong with you communicating with a park attorney. If they don't want to talk to you anymore, so be it. You know, if they say stop communicating with me, well, then I guess you need to stop. But I don't think there's any problem at all, at least at the beginning of the communication, advocating for your client or saying, well, wait a minute, you know, the park wants 3 palm trees to be removed. Doesn't this section of the MRL say they don't have to be removed? I think it's important to establish that this is an agent who's advocating for their client, and they're not going to just sort of kowtow to whatever management says. You know, you want to make it clear that I'm not the kind of agent that's going to do whatever you say because I want to earn my commission and I don't want to be, you know, prevented from getting listings in the park in the future. I'm here to do a job for my client. So initially, I would say, I don't see anything wrong with that. You might cross a legal boundary if you start making a lot of opinions about what the law says and they don't turn out to be correct. That's where I think you need to be careful. I mean, if you're going to quote the law, you obviously are not a lawyer. You can't practice law. It's one thing to say, take a look at this, or here's my understanding. But if you start arguing the law with an attorney, I think at that point you might get yourself into a bit of a problem. And especially if we're talking about an agent, your supervising broker may want to either step in or say, no, that's not for us to do. We'll get our own lawyer to do that. Or one of the parties will get the lawyer. So if the park attorney says, don't email me any further, okay, now I think it's time for your client, the seller, to get their own attorney to communicate with the park attorney and sort of be on a level playing field. Those are the questions that were presented to me in advance. So let's open it up to questions, Ann.
Okay, so basically we're going to alternate between people who have their hands up and the chats that Martha has. So if you want to go ahead and do a live raising of hand, please be noted that I will not be able to see people's hands waving in front of the screen. You will have to raise your hand and have it, because it has to go through the Zoom system so that I can actually see that you have your hand up, particularly with 153 people on the call. So *9 to raise your hand if you're on a phone, and on your cell phone, on your computer, just raise your hand. It's usually down in the bottom. It might be under reactions. The reactions button itself might be under more. So just look at the bottom of your Zoom screen until you can find how to raise your hand, because it's different depending upon what version of Zoom you have.
Yeah, it's in the black bar at the bottom of the picture.
Yeah, in the black bar at the bottom of the screen. So go ahead. We'll start with Dale Morris.
Hello, Dale.
My question is that, and good conversation, Bruce. However, one of the things we're experiencing is we have a property manager that's forcing homeowners to make repairs, both interior and exterior, before the park will approve the buyer or issue a rental agreement. So my question is the selling homeowners only recourse MRL 79886, which is management's penalty for willful violation, and then small claims court? Because what we're finding is that, as you can imagine, by the time you do the small claims court, because she's cost you a sale or they've cost you multiple sales, then the buyer is basically left in economic strain. So that's the question: is that the only recourse in your opinion?
No, the primary recourse, because what you're talking about is a small claims suit that just says they interfered with my sale. I could have some damages. In small claims court, you can't claim more than, I think it's 13,000, it's either 12 or $13,000 per claim. And if you want to, just go in there for the penalty that you mentioned for willful violation, you could do that, but that doesn't really solve the issue. You know, if the park is saying you have to repair the interior or we won't let you sell, that's a direct violation of the mobile home residency law. That if the park won't back down based upon what the agents are saying, or even, what the seller is saying, the seller, yeah, we have somebody open there, but the seller should get a lawyer immediately, who should make a demand upon the park to remove that upgrade or repair requirement.
Okay, thank you.
Yeah, so just to continue, that's a serious problem, and the remedy that you really want to be solving for is the ability to sell your home, to remove that unlawful requirement from the sale process. And if a sale is actually lost because of that, and the buyer will make themselves available to testify that they would have bought the home but for that, let's say they're loan approved or it's a cash deal and there's no issue there, then in my opinion, the park owner could be liable for the lost proceeds of the sale. You're gonna, if you lose a $200,000 sale, the park could be on the hook for $200,000 in damages, in my opinion, if they are requiring something that the mobile home residency law does not allow. I will also say that because of all the issues that seem to be occurring in connection with resales, I can tell you that GSMOL is looking carefully at that issue as its 2025 legislative agenda is being considered. I'll just sort of leave it at that at this moment.
Thank you. Martha, over to you.
Yes, folks, we have so many questions. I just need you to know that I am shortening your question to get to the main point. So the first question is there a new state law that is requiring mobile home parks to paint a red fire lane throughout the whole park? This just happened in our mobile home park with countless cars being towed out of the park.
I am not aware of any such state law. It would be a surprise to me that that would become a state law. If it did, it would have to be in Title 25 of the California regulations, I believe. I'm not aware of that. And I believe that any such action by the park would presumably be in response to what local fire prevention or fire authorities could be requiring. So I would check with your local jurisdiction, your local, fire authorities to see if anything locally has been mandated. Otherwise, it would be more than likely, it would just be the election of the park owner. And you can't just paint the curb red without changing the park rules or announcing what you're doing if it's in response to a local law that requires it, and do it in a way that surprises people, and then they all start getting their cars towed. If you're going to amend the rules, you have to give proper notice, have a meeting, confer. It takes 6 months for the rule to take effect. If it's done in response to a change in the law, then you have to announce that. So that, but no, I'm not aware of any such state law.
Thank you. All right, okay, Brian, you're next.
Hi.
Hi, Brian.
The owner of our park has promised to raise rents to new tenants beginning January 1, well above market value. And she requires 4 times that income for those new tenants. Essentially, it's impossible to get someone new into that park if this rule goes into effect on January 1. It's real predatory. There's no way people 55 and up will be able to display that level of income. And so it's a bit of a crisis. And we're wondering if GSMOL can help, if there's some kind of redress that can happen, or it seems like because we're not part of the county, but part of a city instead, and there's no local laws to protect us, it seems like everyone's telling us we're cooked, we're fried. What can we really do? Or do we all have to hire lawyers?
Okay, well, so it sounds like you're saying, Brian, that you live in a local jurisdiction that does not have rent stabilization, correct?
Correct.
Because if there is no local rent stabilization, because there is no state rent regulation yet for mobile home parks, your situation would be governed by the Muratsuchi bill that I mentioned at the beginning of my talk today, if that bill were to ever pass and provide coverage for those areas like yours that presently have no regulation. But until that happens, there is no restriction on the amount of rent that a park can charge. So the first part of your question, can they raise the rent above market? Look, market rent is whatever a park owner says it is. Literally, a park owner is going to come up with any kind of argument they can to justify the rent that they want. So there's no such thing as, let's define market like on a statewide basis or something. I mean, I've never seen anything like that. So unfortunately, I would say, as to the first part of your question, if there's no restriction on the amount of rent that they can charge it. Again, unless you have a lease with them and the lease governs the increases, then the contract would govern. But otherwise, they can raise it to whatever amount they want. As to the qualifying part of your question, there is no part of the law that specifically governs this income to rent ratio, I'll call it, that the industry has kind of adopted over the last decades. All around California, most parks, whether in writing or just verbally, have a policy that in order to have what the mobile home residency law talks about in 798.74, financial ability to pay rent, they define that as a ratio of rent and housing related expenses compared to income. The vast, vast majority of parks require 3 times income over housing related expenses in order to qualify for residency and prove, again, what the MRL talks about, financial ability to pay rent. Okay. Again, the vast, vast majority would rank that or would implement that ratio by looking at gross income as compared to rent and utilities. I've seen some parks that use net income. I've seen only a very few parks that do what you are mentioning, which is 4 times the ratio. It is my opinion, and you'd have to challenge it in a court of law, but it's my opinion that 4 times is unreasonable. So if there's a rule or a policy that says you have to have 4 times, that would be an interesting case to litigate, because you could bring scores of other park rules and policies into court showing 3 times all over California. 4 times, if you could prove in a court of law that this does what you just said, which has such a chilling effect, once you get to 4 times without any real rational basis for that, it's completely arbitrary and capricious, to use a legal phrase, and we can't sell. And you could bring in the information and say park sales have screeched to a halt. Nobody can qualify because it's too onerous of a burden. And because a park owner is in a much better and more protected position actually than even a lender is, because if rent's not paid, then the park can evict somebody and may end up owning the home. And there's a provision that allows the bank to cure the default at least twice during a calendar year. So the park's going to get their money. Like if a bank owns the home, then the bank's going to foreclose and they're going to sell the house. The park's going to get full paid out of the sale. So they're actually in a position of less risk, in my opinion, than a lender. But I don't agree that 4 times is reasonable. I personally don't agree with that. I think it goes beyond what any lender would require for a loan, for example, to be made. But, you may have to actually challenge it. Maybe if a demand was sent to the park, they would voluntarily reassess and back down. But that would just have to maybe get, determined in the course of that dispute. Good question.
Okay, thank you. Go ahead, Martha.
Okay, the next question is there any requirement that park owners remove the old sub-meter pedestals after PG&E has installed direct service to each household?
My understanding is, and if that's what you're talking about, It's the line extension upgrade, utility upgrade program that CPUC is running, if you will, that I mentioned earlier today. Because the old system is going to be abandoned and a new system is going to be installed, often with a smart meter that's going to be located at the very front of the space where it can be more easily read, the pedestal will no longer have any function. It would be my view that the pedestals will be removed. Now, I'm not sure if the utility is going to do that or the park owner. And I will tell you, I don't have enough information or recollection to be able to specifically answer that question with any real degree of certainty. But it would be my opinion that because it's no longer functional, the pedestal will be removed. If the pedestal belongs to the park owner, that might be the park's responsibility, or the serving utility may do it. One way or another, I think it should be removed because it serves no purpose any longer.
Thank you. Maria Aguilar, go ahead.
Good morning. My question is, AB 2782, being challenged. What can we do? Because I know it was gonna be effective next year, 2025. So what can we do to help? Or what is the status of it?
I already explained in some detail the status. Maybe you weren't on the call yet, but I've
No.
already gone through that and I don't want to do it again. But I'll
Okay.
just very quickly summarize by saying this is a lawsuit that's been filed against Gavin Newsom, the governor who signed the bill. What can we do? We can just wait. We can certainly, if the governor's office reaches out and asks, for any kind of information from us, any kind of facts that might be useful for them in defending the case, then GSMOL would certainly, cooperate with that. But otherwise, we just have to wait for the court process to play out. That's really all we can do.
Okay, thank you.
Okay.
Okay, Martha.
How does the MRL apply to a park that has been converted to a PUD?
As long as the park is still a mobile home park, by definition, then one of two things are true. Either the MRL applies in the 798 provisions. Those are the provisions which govern what we call typical investor-owned parks. The residents have no ownership interest in the park. The park is owned by a third-party person or entity. The 798 provisions that we've been talking about all morning would apply to that. If a park has been converted to a subdivision of some kind, whether it's condominium, any kind of resident ownership, the next section, Article 9 of the MRL applies. And that begins with section 799. And that is the provision that would typically apply if the residents purchase their park, or the park again is converted to some other kind of subdivision or cooperative where there's a recorded declaration of CC&Rs, covenants, conditions, and restrictions, or the Subdivision Land Act has been activated and there's a subdivision map that's actually been recorded. So one of those two provisions is always going to apply. As well, if you are a common interest development, you qualify as what's called a CID, then there's another whole body of law called the Davis-Sterling Common Interest Development Act that would apply. And Davis-Sterling, as we typically refer to it, many times applies to resident-owned communities.
Okay. Since some people have left the call, I wanted to just inject at this point because I don't want them to miss it. If there are real estate agents on the call, and I know that I've recognized a few of them, we are going to try to present helpful information to real estate agents as we work our way through this interference with home sales issues. And we'd like to have you on an email list. If you would like to be on that email list, you can email to membersupport@gsmol.org. Membersupport@gsmol.org. That will come to me. It will also go to the GSMOL office, so, you know, we can have that all on record. But please do contact us if you would like to be in on whatever information we can send to you regarding these kinds of issues.
Yeah,
Okay.
and we'd like to hear from them as well, Anne,
Yes.
about any kind of issues that they're experiencing, because those are the kind of facts that can form the basis for future legislation, to be honest.
Exactly.
You know,
That's one of
very
the main
valuable.
reasons, yes, that we would like to stay in touch with real estate agents. And please do send us what you can of the issues that you've been experiencing.
I think Marlene just put a question into the chat.
Okay.
About
I'll take her
can
hand down.
residents audit utility bills? I think was the question, right, Marlene? And then they just logged off of there. So can you audit utility bills? Well, I mean, you can certainly request that the park owner provide the basis for any meter readings that they're charging to you. You can certainly also start trying to, you know, on your own, take a look at your own meter and log in, you know, daily or weekly numbers to see if the readings are being correctly recorded. If you're in a park with sub-metered gas, sub-metered electric, or sub-metered water. But you can also go to the serving utility and you can ask for information about, you know, for example, with electric, you get charged in tiers. You know, if you have a certain number of kilowatt hours, it might jump you into another tier and the charge is different. You can absolutely go to, you know, Edison, the Sempra utilities, PG&E, for gas or electric, and ask questions and presumably get any information about how the charges are to be calculated. But you always should be able to get confirmation from management if you think the meter is not being read correctly or there could be something wrong with the meter. If you think the meter is malfunctioning, contact County Weights and Measures. There's always an office in every county where you would live called Weights and Measures. They could come out and they could test the meter to make sure that it's functioning properly.
Thank you. Martha?
Can management rent out the clubhouse to residents or outsiders and close it during that time to all other residents?
Even though the mobile home residency law says that the clubhouse should be open and available at all reasonable hours, I think it would be allowable, and it is very typical in my experience in mobile home parks, that management could allow a resident to reserve the clubhouse for a day, for half a day, for an evening, for, you know, a wedding reception, a funeral, a bar mitzvah, a private party. Now, I think that the tension here is management couldn't be renting the clubhouse out all the time so that the other residents of the park are being denied access. But it'd be unreasonable to say they could never do it. I mean, I think we all know that that's a very typical thing that happens occasionally in parks. I think that in order to do that, though, there has to be a resident involved. If the park says, and I see this in the chat right now, if the park says we're renting it out to people who don't live in the park, that's a problem. Because now they're making extra income off of non-resident usage, which denies the residents of the park the ability to use the clubhouse because you're getting a separate income stream for it. If the funeral, the bar mitzvah, the wedding reception involves a resident of the park, I think that's fine. If outsiders, non-park residents are being invited to that function, I think that's fine. But I think it always should be hosted by, requested by, or involve residents of that park. It shouldn't be complete, you know, outside unknown people who are coming in and basically taking over the use of the clubhouse.
Thank you. Okay, Pam Gentry Furcrest, go ahead. Take yourself off mute.
Hello, Pam.
There we go. Hit the wrong button. Yes, I'm the one that put in the question about the sub-meter pedestal removal because they removed ours about 5 years ago. I mean, they didn't remove them, unfortunately. They put in direct, PG&E. We now have direct billing. I mean, direct service. Anyway, some of those meters are sub-meters are still live and some aren't. And we've had a lot of our residents are saying, why can't they get rid of them? And they're saying, well, it's because there's kind of, this is an old park and they're all kind of interconnected in a way that would be impossible. So I'm just wondering if there's anything else that could be done.
Well, when you say they are saying that, who's they? PG&E?
Management, not
Oh,
management.
I would go to your PG&E, right? You're in Furcrest.
Yeah, but they say they don't own those sub meters. They say it's not their responsibility, and that was not in the contract for them to remove them.
Okay,
So
well then,
we already have people looking into it.
well, that might be true because that probably is true that the park literally owns the pedestal itself. But if you say those are still live, to me, PG&E should know about that
Well,
because,
that's what we were thinking, that it's a hazard
well, yeah, I
because the
mean,
wires, some of the wires are very close to the surface and so on in people's spaces. And
I would say it's either an issue that PG&E needs to be notified of immediately and get somebody in their safety division involved. There's a safety division of the CPUC as well, that maybe you could contact the safety division in San Francisco, but I'd also contact PG&E, try to find out what their position is. And then maybe even HCD might
Mhm.
come and inspect and say, we can't have live electrical connections going on here. This is a definite
Okay.
hazard. It could be, a health and safety issue of great magnitude.
Yeah, because I guess what management is saying is that's the reason that they're still live is that they're being used for the pool and the clubhouse, that electricity, the old, I don't understand it, the old legacy system it was called, is being used for that. I don't know. It's very confusing, but yeah, and the manager's manager, Evans, anyway, she's saying it would be way too expensive. We're not doing it, and then people are saying, well, maybe we shouldn't push it because then they might try to, do some of the things like are happening at Youngstown. I don't know. It's kind of a mess.
Well, health and safety can never yield to the cost. So if
Right.
management says we just don't want to do it because it's too expensive, that's not going to fly if indeed there is a health and safety issue. The old system is called the legacy system. That's just
Right.
used for the old
Right.
system.
Right.
Again, if this particular system is very uniquely set up in such a way that those pedestals have to stay there to power the common area facilities,
Mhm.
I mean, that's beyond my knowledge that that
Right.
would be
Right.
true. But and I don't remember ever in all the workshops and the hearings that I attended in San Francisco
Mhm.
for like 8 years, I don't ever remember that question coming up.
Hmm.
Maybe it did, and I just wasn't,
Hmm.
listening, or it came up at a proceeding I was not at.
Mhm.
But I would be looking into it by safety division at CPUC, PG&E, and possibly HCD.
Okay, thank you. Can I ask one other real quick question that I put in? Can it be required that a person goes through a real estate agent to sell their mobile home in a park?
No,
Okay, because people have told me otherwise. They said, "Oh, you have to." That's not in the
no,
rules. It's not in MRL anywhere, right?
no,
Okay. Okay. Thank you.
sure.
Thank you, Martha.
Yes, some of these questions I believe are need to be investigated by your regional manager or your chapter president. They're unclear, but Bruce, I will ask you the question
Okay.
and perhaps you agree
Yeah,
with
look,
me that they should be directed to their regional manager or chapter president. Here's the question.
Okay.
How can I enforce my right to tenancy under the MRL when the park fails to acknowledge my rights and actively prevents and prohibits me from taking possession of and occupying my home?
wow. I mean, I'd have to know a lot more facts
Right.
that underlie that. I mean, hey, Pam, why don't you go on mute now? That's okay. I'd have to know a lot more facts that would underlie that question. I mean, it sounds like somebody's saying I bought a home and they're not going to let me move into the home. Um, I'd want to know, well, what are the reasons being alleged for that? Are they saying, you're not on title, or you actually you applied for tenancy, but you were denied tenancy? I mean, it really depends upon what the reasons are for the denial. It's kind of a hard,
Right.
it's a little bit too broad for me to answer. Otherwise, if you have been approved for tenancy, you signed a rental agreement when you moved in, there, you're paying rent, then you can't be denied occupancy, and it would be a violation of the mobile home residency law.
Can I make a comment? This is Michael. I'm the one that submitted the question.
Sure, go ahead.
Yeah. So the home, I took possession, or I took ownership of the home. And because now I'm trying to move in and take possession, and they've refused the rent payments, they return them, and they say that I'm not approved, even though the MRL, I was approved verbally, but they didn't follow the rules regarding the MRL. And the MRL does provide, if there's a failure on the park's part to follow the law, then by default, I'm allowed to be an occupant, and I'm not, or a tenant, and I'm not considered to be trespassing. But they are threatening to arrest me if I come back, if I am in the
Okay.
park premises, and so on and so
Okay.
forth.
Well, first of all, you said something that's not literally true. The MRL doesn't say by inference you're ever a lawful occupant. That's just not true. If you're purchasing a home or you're inheriting a home and you want to qualify for tenancy, you must fill out an application, you must
Right. And
submit it.
yes, and the application was submitted. Yes, and it was not rejected, and it was approved verbally, but they never notified in writing.
Okay, well, that's kind of problematic though, right? Because you say it was approved verbally, and if they come back and say, no, we never approved it verbally, then it's a swearing match between two people with opposite
And that's where
stories.
then the law says that if they don't, they can only reject for certain reasons. And if they don't reject in writing, then it is considered to be accepted.
That's not true. No, that's not.
Maybe I misread it.
Yeah, that's simply not true. No, I'm not aware of many situations, to be frank, that I've ever seen where there was not a written approval. And in fact, if you're an escrow to purchase a home, the MRL specifically requires that escrow cannot close unless one of two things happens. Number one, there is a letter in escrow from management confirming the approval in writing. Or number two, a rental agreement, a signed rental agreement is put into escrow. If you don't have either one of those things, and I don't know if escrow was used when you acquired the home, but
No, it was given to me as a gift.
well, okay, but yeah, if it's given to you and there's no escrow, yeah, I mean, I think
And
you
there was an I submitted my application, and they did not approve it until 3 months later. And that's when they verbally approved it. And then they said it had been approved within the 10-day period, but it hadn't been. And it was
okay,
never in writing. It was
it's a
only verbally.
yeah, it's a pretty unique question, but I can't really answer better than what I'm saying. To tell
Yeah.
you, there's no such thing as an implied approval in the law right now. That doesn't
Okay.
exist. So, I
Is
mean,
there,
you may have a cause of action to say, you're blocking me from the gift that I received, and you probably need to get an attorney. Yeah,
okay.
best I can offer. Sorry.
Okay. Okay, Bonnie Canner, go ahead.
Hello, Bonnie.
Hi. I just messaged Lisa, who's the other person, to let her know to take it off mute. I have a question. It's regarding trees, actually. When I moved into my property, I had actually 8 very large, tall trees that go way above the home now. And 4 of them had to be removed because they were too close to each other, and the concrete was warping and getting cracks, and the home is
Okay.
not level. Okay, well, now that's been a couple years, and what I found out during that process with HCD and GSMOL is that when the trees are above the roof line and their branches are hanging over the roof, that is a danger, and that's when the park is responsible for the trimming. that I'm responsible for everything below the roof line. The interesting thing is when I bought the home, I wasn't told that the park was responsible for large trees like that. And they had me believe that I was responsible for the trees on my lot. And it's been like an argument. I had to have attorneys that helped me to get them to remove the 4 trees and trim the trees. But they constantly threatened that, at least the old managers, I don't know about the new ones, but they constantly threatened that if I request that they trim anything, that they will come onto the property and just remove all the trees. Are they allowed to do that? I mean, it's my environment and I don't want them to remove the trees. I just want them to
So-
protect the roofs of my house and my neighbor's house from them because they're like 60-foot tall.
Okay, I think I get the question, so we can try to get the answer in here. First of all, the park owns the trees, unless they're trees in like a pot or something that you could take with you, you know, when you sell your home and move. So they're fixtures to the land.
Right?
Trees and driveways are both governed by Civil Code 798.37.5. And 798.37.5 says that if a tree is a hazard or a health and safety violation, it's the park's responsibility. Doesn't matter who planted the tree, doesn't matter how tall the tree is. While what you said could be true, which is maybe it's typical that a tree portion above a roof line may be more often than not a health and safety issue if it's dropping, you know, branches or, you know, pieces. But it's not literally always the case. You could have a health and safety problem for a tree that's very small, but the roots are uprooting concrete or causing a home to go out of level.
That's
So
what's happened
it's
in my
not
house.
specifically going to be above roof line or below roof line. That having been said, that's the test. The test is if you say, I got trees that are, you know, I didn't cause them to get diseased, they're dying, they're falling over, they're dropping pieces, they're causing my home to go out of level, they're busting up concrete, they're causing trip hazards. That's the park's responsibility. They may have to remove a tree to solve the problem. They might have to do a root block. They might have to, you know, cut part of it back. You know, we just don't know. But I would say to you this, if you want something done and they say, well, we'll just remove the tree, you don't really have power to stop that from happening. It's
Oh
the
my God.
the
That would be
park
awful.
the park has in general the election to say we're going to remove a tree. However, if they just come in and start removing trees that provide shade, provide very valuable benefit to you, and they just say, we just don't want these trees anymore, we're going to remove them, you could have an action, in my opinion, under certain circumstances, possibly for breach of contract. You know, could you get an injunction to stop the removal? I'm not sure about that. But if your space is devalued because of that, one could possibly argue that you should get a rent decrease. Also, if those trees provide valuable shade, let's say, because of the, you know, east-west position, maybe especially west position of the sun, and removing the trees makes your house unlivable, I think you'd have the ability to say to the park, what are we going to do about this? You got to either allow me to put some shade up, we got to erect something. Something has to be done to allow what the tree provided previously to be still, you know, given to me because I need it. So, I mean, there's a park in Sacramento County that's been just going crazy with this and saying, we're removing all the trees in the park, you know, just like crazy stuff is going on in that park. To me, that's not reasonable conduct by management.
One other issue with the trees, I'm against a hillside, and there are things called castor bean trees that grow like crazy on my hillside. And I didn't know until recently that when they take them out, they grind them up and they end up shooting what's left of the trees towards my house. So I get like green and brown stuff all over my house, and it was going into my house and I was breathing it in. And I was getting asthma and breaking out in rashes, and I didn't put two and two together to realize it was the castor bean trees until it grew in my yard, and I went to pull it out and I got a rash all over me. And then I did a check with my plant, what is this? And it told me, picture this, told me what it was. Well, people don't realize that the little berries of castor bean trees are ricin. It's ricin poisoning.
Okay. So what your question is?
My question is, shouldn't there be a responsibility to the park to keep those things removed, not shoot them towards my house where they're making?
I would say yes, very well, there could be. If you can show that there's a hazard, especially if it's affecting you allergically or some other way, then I'm not a personal injury attorney
So you
by
think I should
trade.
have the soil tested to show that it has that it's ricin poisoning and to stop doing that?
Possibly, yeah.
Yeah.
I've never heard of any of this, what you're mentioning, but sure, possibly there could be, yeah. I
Yeah.
mean, it's kind of like a mold issue, right? I mean, you shouldn't be, as a tenant, even though you're called a homeowner, of course, because you own your home, but you have a tenancy with the park, and you're entitled to something called quiet enjoyment. Under
Right.
California law, all tenants are required to be given quiet enjoyment in their tenancy. And if you're getting sick because of conditions that the park, because it owns those trees, could ameliorate, my argument would be upon adequate proof of what's going on, the park
Mhm.
would have a duty to make it stop. Yeah.
Okay, so you are correct, and I won a lawsuit against that. But most people are not aware, like you weren't aware of what ricin and castor bean trees are.
Okay.
Oh, yeah, they have to take it out now by my house, but they're still growing in other places in the park, and they're only doing it in my area where I live now. And they're not allowed to grind them. They have to pull them from the roots, and it's a hazmat situation. They have to make sure that they're covered when they do it. So it was more for information. Thank you.
Okay. Thank you for
Thank
that
you.
very much. Thank you.
Okay, Martha, go ahead.
Yeah, this is a little bit unclear, Bruce. I'm not sure what they're asking. The question, the statement is, we just had a 90-day notice of rent increase after they paved the park, and the increase was $45.70.
Okay, well, under the mobile home residency law, a 90-day notice of rent increase is required. The notice does not have to state a reason. It may state a reason, but that's up to the park owner to make that decision. And if you have signed a rental agreement that allows for capital expenditures to be passed through, then that may be perfectly legal. If you live in a rent controlled or rent stabilized jurisdiction, then there may be a process that has to be followed. If you don't have any rent stabilization, then the park could certainly raise the rent on 90 days notice, and they could state that as a reason.
Okay, let's go to Dan Hazen.
And thank you. You've actually answered a couple of my questions, so thank you.
Oh, good.
My first time on. I may be a lone wolf in this trailer park. I'm in Porterville, California, so very likely I'm new to this process. I'm trying to find out a little bit more now that you mentioned that you're not aware of any red fire lanes. They literally put the whole park under red fire lanes, hauled a bunch of cars out. We have about 24 different cars now parked outside of the trailer park because this is a family park. It is not a senior park. So I don't know if there is a difference in the way that they look.
No.
Okay.
Well, I mean,
So
let me say this, Dan. It's not unusual for a park to have a rule that says you can't park in the street. That's a very common rule. The exception is, of course, if you pull up and you have, somebody who's not ambulatory or handicapped and you're bringing them in or out of the house, you get to very temporarily stop there for that purpose. If you're pulling up to unload groceries, you get to do that. Temporary stopping should not be enforced with, you know, a tow truck like a vampire bat hiding behind a shed and then just zipping out and jacking somebody up and taking their car away while they're putting their groceries in the house. But it's very common for a park to require that the roads be clear of parked vehicles because they are needing, depending upon, again, the width of the roadway, there's a minimum required, but you need to have access for emergency vehicles, ambulance, fire, police, whatever it might be. So that's a common rule. There's no right to park in the street. But when you're painting the curbs red, that basically means no parking, never, ever here. And it's like there's no zones where anybody can park. And then it makes it look like, well, this is like really more than just rules enforcement. This is law enforcement enforcing this now. So my understanding, and I'm no authority, great authority on this issue, but my understanding is that a park cannot unilaterally paint curbs red without authority to do that. And that the authority typically comes from the local enforcement agencies. So I would be checking with your local, I'd start with your, you know, the fire department. I might check with the city manager's office and just try to get as much information as you can that may have been relied upon when they did that.
Thank you. I appreciate, because it's like, this is draconian. This just happened. And I had to keep talking to management, and they kept threatening me every time I pull out front, or other family members or friends that come and pick up my 94-year-old mother-in-law, and they would threaten to haul off our car. And I'm thinking, wait a minute, we've been doing this all along, and that's all we're doing, picking up, dropping off, or with groceries. Manager would come out and threaten to pull.
Like I said, they can't,
out.
yeah, I mean, if they want to try to tow you for that, good luck. But I don't know that a tow company is gonna want to get involved there because they could have liability too. And if there's towing, they have to place signs at the front and back entrances of the park that talk about that.
Thank you.
Okay.
I'm gonna check a little
Thank you.
further into regulations. So thank you for the answers.
Sure.
Okay.
Somebody had
Martha.
posted it in chat about the subletting issue. Do you have questions about that, Martha?
I'm looking at the top of the page, Bruce. Can I take the first question and
Go
then
ahead.
figure
Yeah.
out later? The question is, can the park management be selective about which park models can't be sold in place? Can they discriminatorily allow one and not the other?
Well, I guess they could try, certainly. Whether that really is, you know, enforceable. Once you start being arbitrary, it starts to look like you're just picking on people and you're being arbitrary and capricious. You're not being, you know, uniform in the way that you're enforcing a rule. I think at that point, you're jeopardizing your ability to actually enforce the rule. Because if there's a rule and you're just selectively saying, today I'll enforce it, tomorrow I won't, one of my arguments on behalf of my clients is you've waived your ability to enforce the rule. It's either all or nothing. If there's a rule, you have to enforce it unilaterally. I'd have to know more information about why some park models are being allowed to stay and why some are not. And I'd want to know, is there any rational basis behind the decision? Or are they just saying, well, we like Bob, so we'll let his sell in place, but we don't like Carol, so we're not going to let her stay? I would really need to know more information. I guess my answer is it could be discriminatory, but I just don't know.
Okay, Lauren, I need to tell you, I answered your question in the chat. But your question was about subletting. There is a new law that says if the park owner is renting out units, that you can do the same thing.
Yeah, that's 798.23.5. Lauren, please refer to Civil Code 798.23.5. Martha's correct.
Okay, good. All right, person calling in on the phone, the last four digits are 0704. Take yourself off mute and go ahead.
Okay, hi, thank you. My question is there a legal limit to noise levels allowed in the park? My example is wind chimes since myself and my neighbor live in a wind tunnel.
Well, that's really an issue. When you say, is there a limit to noise? I guess in general, I would say that any noise may rise to the level of a nuisance, depending upon, what we're talking about. So there's general nuisance law that if noise interferes with your quiet enjoyment, yes, there may be prohibitions on that. As far as a level of noise, that's going to depend upon your local law. And I'm going to just give you an example. I represented a lady for some time. She was consulting with me. When she bought her home, it was right next to a tennis court. After she bought the home, they turned it into a pickleball court. Pickleball has a very percussive, steady, loud noise associated with it that tennis does not, just because of the kind of ball and racket that are being used. And one of the
Correct.
things she researched with the locals is, is there some kind of a noise ordinance that can be enforced here? And you have to actually have acoustical engineers come out and measure the decibel level. I am not sure how wind chimes are going to be, ranked, but that's really what I could tell you. There's nothing in state law that I know of about decibel levels. I think it's going to be a local issue, but otherwise, if it's a nuisance, like, somebody's doing construction in the space next to you, especially during off hours, decibel may have nothing to do with it. It's still a nuisance. So that's
Okay.
kind of my answer.
Is there like a code number that applies to general nuisance law?
Well, not
Or-
really. I mean, there are
Okay.
some sections of the code. I can't cite them to you. I'm not prepared to cite them to you here and now.
Okay.
There are some sections that talk about nuisance, but in a lot of ways, nuisance is a function of cases as well. There's a lot of case law about nuisance. There are some sections. Yeah, you'd have to try to Google that, or search for them. Nuisance law is a big, large body of law for sure. I mean, it could govern all kinds of things. Nuisance may have nothing to do with sound. If somebody puts a basketball court in just outside your park and the lights are shining in the middle of the night into your house, that's a nuisance too. So different kinds of nuisances.
Okay.
Smell could be a nuisance.
Thank you.
Yep.
Thank you, Bruce.
Sure.
Okay, Martha, go ahead. No
Yeah,
hands up right now.
Bruce, in order to move this along, I'm combining two questions.
Okay.
It says, what interior items are allowed to be inspected and required to be repaired or fixed before a sale can be approved by the park? And then this person says that she or he is assisting residents in his or her park. And she says Title 25 inspections require GFCI outlets be installed outside. All electrical outlets are functional. Electric boxes inside have correct plate covers. No plumbing leaks. That she says, or he, are there any other specific interior items park management can mandate for inspection and repair? And then
Okay, I got the question. I got the question. I've already answered it, but in my remarks about the section previously, but I'll go back to it. Civil Code 798.73.5 is very clear. The only repairs or improvements that can be required on resale are exterior. There are no interior improvements that can be required. However, if somebody gets an interior inspection and code violations are flagged in that interior inspection, then those should be corrected. Now, management can't mandate the inspection, in my opinion. There's nothing in the law that says they can. Management doesn't have independent ability to say, you got to fix all this interior stuff. Could be aesthetic, could be code. But if somebody does get an inspection and it flags code violations, I would say, forget about management for the moment. Those should be fixed. I'm not an electrician. I don't have, specific knowledge of what of the other receptacle or plumbing issues that you're raising, and I'm not an HCD inspector, so I can't go through a list with you here about, what kind of things an interior inspection might turn up or what needs to be done. You really need to rely upon an inspector for that, or rely upon HCD, the state. Or if there's a local enforcement agency, you'd want to rely upon them. But in general, the park cannot require any interior improvements.
I would like to add to that something that I learned from Kevin Hootman, who is in charge of codes and standards from HCD, that HCD does not do sale inspections. So
They used to, but they don't anymore.
they don't anymore. They did used to do that, but they don't anymore. And so you can have anybody who is a licensed certified inspector inspect your home. As far as the park is concerned, that should be sufficient.
But when you
'Cause
do
I
work,
have seen some parks,
you-
I've seen managements of some parks saying you have to be inspected according to Title 25. I've seen that in some of the things that people are getting when they're trying to sell their home.
well, yeah, management can't require any inspections, really.
Yeah.
They do their own inspection to determine the exterior upgrades, but they can't, as I've already stated today, there's no law that says management can require inspections, even though they're a good idea. I will say, though, that if work needs to be done on the exterior, it is reasonable for management to require a contractor with a C-47 license for exterior repairs. In my opinion, I think that's reasonable.
Yes. Okay, next is Bonnie Canner. Go ahead, Bonnie.
Hello? I'm
Hello
reaching
again.
out. Hi, I'm reaching out not for me, but iPhone IKN has been trying to get her hand to go up again. You've called her twice, but she didn't hear you when you were calling her because she didn't know her thing was iPhone IKN. She didn't know that's what it was called. So can you please, she just unmuted. Can you please have her talk instead of me?
Sure.
Okay,
Hi.
sure.
Boss, I don't know why my name isn't coming up or my phone number.
Your phone number is there, but we saw a screen name and that's what I was going by.
You're on now, so
Oh,
go
I had
ahead.
no idea. I'm in the Palisades Bowl mobile home community. I'm a 33-year resident and a realtor now as well. So let's see, what's my most pressing thing is that I have a sale. It's an old trailer. We've gone over that. Now we're stuck is that the new management is trying to say they are not going to issue a new lease agreement to my buyer that's an escrow, who plans on putting a new home on there, or they're offering her an $1,800, $900 increase on her rent agreement, which is against rent control and all that. So we're trying to navigate what to do to make this process go without hiring an attorney, hopefully, but if necessary, I guess we'll have to.
Yeah, I mean, it's kind of hard, sorry, for me to really answer this because sounds like there's a lot of moving parts and facts and
Not really. It's an old trailer.
well,
Buyer,
but if I may, you just mentioned a number of things. You've mentioned, the issue is they're going to raise their rent under one option. I'm just saying it's going to be hard for me to answer specific issues like that. Could you try to maybe break your question down more specifically for me? That would help.
how do we get a legal rent controlled agreement with the management for a home
So
sale?
the home is located in a jurisdiction that is governed by a rent
LA
stabilization. I'm sorry, like if I could ask my question.
County,
Yeah.
LA.
Oh, you're freezing. I'm sorry.
Oh, no. Can you hear me
Okay,
now?
so you're saying that it's governed by LA County Mobile Home Rent Stabilization?
Yes.
Okay. And if that's true and the ordinance is being violated, then you should contact the county. You should contact
did.
LA County.
I
What did
had
they
the
tell you?
make a formal complaint and the owner.
Okay, and so what was the result of that
We're
complaint?
not hearing anything. It's weeks and weeks and weeks, and we're in escrow stuck.
And so you're in escrow and you've been repeatedly reaching out to the county and they're
Yeah.
not giving you an answer?
Yes.
Then you may need to hire a local attorney, I guess. I don't know what else to say. I mean, the county should be enforcing their ordinance. If you're telling me that the park owner is saying, we'll only improve the buyer if the rent's gonna go up,
Right.
in violation of the ordinance, if that's the essence of what you're saying,
Yes.
then I would say, unless there are facts that would prove otherwise, it sounds like on the surface of it, it could very well be a violation of the ordinance vacancy control provisions, we call them.
Right.
And so I would say, yeah, and you may need to get heavy artillery to come into the picture to contact the county and say, look, are you going to enforce the ordinance or not? What other facts do you need from us? We need you to tell the park owner that this is illegal.
So are you saying I need to hire an attorney to do that at this point?
You may very well, yes.
Do you know of one that you could refer? Because this is such a specialized.
Well, I
Could I
mean,
make a suggestion?
Sure.
yeah, go ahead,
Yeah,
Ann.
you're in LA County, maybe
Yeah.
it would be a good idea to contact our zone vice president that covers that area. Have you,
Mary Jo?
I'm sorry?
Mary Jo?
Yeah, Mary Jo.
I already did 100 times.
Oh, dear.
Yeah. I'm at my end of my rope.
I mean, I can't refer you to an attorney in LA. I would just say there are many attorneys who handle real estate transactions and real estate law.
Yeah, but they don't really get involved with mobile home law unless they really know it.
Understood. As somebody who's done mobile home laws, especially for many years, I perfectly understand and agree with that statement. But I'm just saying, unless you can find somebody else in your area, you may still want to ask real estate attorney. They may have had some exposure to it, and they may say, it's a pretty basic issue. And if you just want us to come in as heavy artillery to contact the county, we're willing to do that for you.
Just contact the county to not necessarily the management or owner
Well,
here.
there's two things. I mean, now we're getting into a specific legal issue, but to move the discussion forward, there's two things. You want the county to come in if the county is at all capable or willing to do that. But the other thing is you want an attorney who does real estate law to make a demand on the park to say, if you don't approve this transaction, we'll sue you. We'll sue you for wrongfully denying the sale.
If you don't approve. Okay, got it.
Yeah, because you're interfering with the transaction. You're not allowing escrow to close because this buyer's not going to agree to that rent increase.
No,
For every $100 that the rent goes up, the equity in the home goes down by $10,000. That's the paired analysis that's been pretty well accepted in the industry if you're in a coastal, high density kind of community.
right.
So, these are significant damages. And
Yeah,
I would also be demanding of the park owner, what's your basis for raising the rent?
they're saying that because it's going to be removed and there's a new home going in, that and the person's not buying, they don't own the land. And I'm like, well, I know that, I've been here 33 years.
Can I offer a suggestion?
Yes.
Maybe the buyer needs to back away from this idea that they're gonna remove the home immediately. Maybe the buyer needs to just buy the
That's
home.
part of the agreement because it's an old disheveled trailer.
Well, then that may be your problem, and that's why I'm saying that there are unique facts here that really there are a number of moving parts, because that may be the issue where the park owner is saying, we don't have to let a new home in here as part of the
They
deal.
want a new home in there. They want that to be removed and a new one put in. We
Okay.
agreed to that when I put it up for sale a year ago.
I want to make sure we get to other questions, but
Okay.
yeah, that's a variable that's affecting all of this, I'm telling you.
Oh,
And
gee.
there's no law that says a park must allow a pullout to happen at the point of sale. So
Well-
I'm just telling you that if that's the wrinkle, the county is going to have to make an opinion about that. And
Well, that was the agreement that when we put in the notice to sell, that
yeah, but the park owner wasn't part of that agreement, were they?
yeah, when you're selling a place, the owner puts in a notice to sell.
No, but the
And
park owner didn't agree to the pullout, is my point.
yes, the management did.
Okay, well, then there's a contract that I'd have to review before I could answer you more specifically. Maybe there's a breach of contract claim. You know what, though? We're getting into the weeds. I'm sorry, and we're almost out of time, so.
I've missed my yoga class and I've sat here for 2 hours trying to get some answers.
Well, but that this town hall, though, with all due respect, is not about
I know.
solving specific legal questions.
I know.
I've given you the
I'm
most
learning a lot, though.
information. I'm sorry, I've given you the most information I can give you with the very limited facts that I know. I
Yeah,
can't give you any more, so hopefully
okay.
it's been some help. Sorry if it
Yeah,
has.
no,
You need to book a consultation with an attorney and really drill deep into the facts. Okay, do we have more? Because we're almost at 12:30 and my hard stop is fast approaching here.
Okay,
Yeah.
Martha, go ahead.
Yeah, folks, I'm gonna take short questions that Bruce can answer quickly. Hopefully, is it legal for a manager to lock and close the clubhouse during holidays and or when she is not on the premises?
The answer is no. The clubhouse has to be open at all reasonable times. If they have a key system where you have to get a key or go to the manager to get, a card or a key to open the clubhouse, that may be perfectly acceptable as long as it's easy to do that. But for the manager to simply lock it up, in my opinion, no. That's a violation of 798.24 of the mobile home residency law.
Okay, very good. So go ahead, Mary.
I had the question about the home next door to me that the park is taken over. They're gonna do these remodels that they've been doing to all these dilapidated homes in the park that they can get their hands on. So really my question is since it's so deteriorated inside and all the inspections are about what is on the outside, how can I generate an inspection if they like for instance in the Title 25 1606 substandard mobile home units, am I able to write to HCD and get them to do some kind of an inspection on that home before they issue a permit, which I think is an application, HCD 415 for doing alterations because the home is so dilapidated and I believe a hazard to myself and everybody nearby because every time they're doing these things now, it goes on for months. They're all full of mold. They're 50 years old. They're rotting away. And they found that the only way that they can make more money in the park is to keep rehabbing these dilapidated places when they should just really be pulled out of here. Do I have you have any suggestion on how I could move forward to?
Yes, I do. Yes. So I don't think that you can mandate that HCD come out and inspect the interior of a home. And I don't know that you can sort of blow the whistle on somebody to say, I think you should come out and see whether they got a permit to alter. But there is a complaint you can file online. You can file a health and safety complaint. And I'm not talking about an MRLPP, a mobile home residence law protection program complaint. There has been for many, many years, long before the MRLPP existed, you can file a complaint alleging that there is a health and safety issue in the park. And if you provide adequate evidence, I believe HCD will come out and inspect to determine whether there is a condition on that space that is a health and safety issue for surrounding residents.
Okay.
And you can do that online. You should be as specific as you can be, attach photos if you can, but absolutely, yeah,
Okay. Thank
Thank
you.
you.
sure.
All right, Martha.
Sounds like a troubling problem.
Yeah, this is a follow-up to something you said earlier in the meeting, Bruce. The person says the MRL says park owners can only require mobiles to be moved out of the park for specific reasons. Since park models fall under the protection of the MRL, are you saying owners can require those types of mobiles to be moved upon sale?
Yeah, let me reiterate what I said when I answered that question during the pre-submitted questions. A park model which has been in place for 9 or more consecutive months on a space is entitled to all protections of the MRL except one, and that is the ability to have it sold in place where it remains in the park. If you look at the definition section in the MRL, section 798.3B 798.3B of the Civil Code says, for purposes of this chapter other than 798.73, RVs, which includes a park model, is the same as an RV by definition, get all the protections of the MRL. So if a park model, if the park owner says, even though this is in great condition, there's no code violations, it looks beautiful, we just don't want it here anymore because it doesn't qualify under the definition of a mobile home, as the law is currently stated, the park can require that it be removed as a condition of sale. Just a couple
Okay.
more if we can, and then I'm going to have to sign off for the day.
Okay,
So we have George next.
okay, let's have George Senko. Go ahead.
Hi, real quick. If a park management owner rents out units at whatever he wants to rent it out, can he limit what a resident can rent his unit out for?
The law, George, does not say anything about that. There's no provision that was passed in connection with the subleasing bill that really spoke to that issue. I'm aware that the park might take the position, well, we'll let you sublease, so we're not in violation of the law. You can sublease, but you're limited to the amount that you can charge. I'm well aware that a park could try to implement a rule that would say that. I would first say it must be in the rules, number one, or it must be in a rental agreement that you signed. You might know, George, that under the provision for a medical sublease that's existed in the code, before we ever passed the more recent provision, that under a medical sublease kind of an arrangement, which is a 12-month limited term, that provision of the code said that the medical sublessor cannot charge more than what they were paying. In other words, they can't make a profit off of the medical sublease. There's just no provision of the current law as it was amended to open up the subleasing opportunities. There's no provision that speaks to that one way or the other. So I would say it would have to be reviewed according to reasonableness, and whether it's arbitrary, capricious, whether it's being uniformly enforced. A park is going to say, we don't want you to make a profit off our land. I mean, I get that. I get why they would say that. So yeah, that's probably an issue that's going to either have to be court tested, or maybe the law is going to have to be more specific about that issue.
Okay, thank you.
Sure.
All right, Martha, back to you.
Just a couple more.
Yeah, the question is, can a park tell a resident you can only take advantage of rent control if you do a month-to-month lease?
Well, of course, if AB 2782 takes effect, all rental agreements are going to be subject to rent control. But the law is that anything over 12 months would be exempt. So month-to-month agreements are covered by rent control, 12-month agreements are covered by rent control, 6-month agreements are covered by rent control. But now, you know what, it may not matter one way or the other. And certainly any new agreement now is going to be covered by rent control, no matter what the term is. Yeah.
Okay, 7482 is back. Go ahead and take yourself off mute.
Oh,
Let's
thank you. Thank you so much for taking my call. I didn't realize it was *6 that would take me off mute. This is Dale Morris again. I have a question for you, Bruce, when it regards to the inspection. One of the things we're finding is that the park is demanding a copy of the home inspection report. So they're not doing their own inspection, exterior inspection. So what ends up happening is they actually have the information about the home being sold, and they're using that as their quote-unquote health and safety inspection. So my question is, does the homeowner, the realtors, whether selling or the selling agent or the buying agent, do they have to give the park property manager and or the park a copy of the home inspection?
Well, I doubt that there's a rule that says that, right, Dale? First of all.
Right.
I doubt that there's any rule, so that would have to be some kind of policy or just some kind of ad hoc transaction by transaction demand, which I think generally speaking, that's not enforceable anyway. But I would also say that it would be interesting to me that a park would not conduct their own exterior inspection because their inspection is going to be totally different than a paid inspector. When management inspects, they're not only looking at code issues, they're looking at rules issues. When an independent inspector inspects, they're only looking at code issues. They don't get a copy of the park rules and, take a look at whether or not something on the home site violates the rules. So in my opinion, it would not be wise to begin with for a park to rely upon third-party inspections. But no, I don't believe that there's anything that mandates that the inspection must be given to the park. And what you wouldn't want to do is give it to the park and then have the park say, aha, well, you have to do all this interior stuff too now because you showed me the inspection.
Exactly, and to your point, and real quick, that's exactly what's happening. Exactly what you described. The home inspection basically points out various codes that the GFI that may need to be repaired to meet code. So they're using that as a means to, again, for their own. At least this park property manager, from what I can see, she's using that as part of approval of the sale. Is the code violations that might be pointed out in the inspection report. But again, thanks. Good job. Talk to you later.
Yeah, and I would just close the discussion on that by saying that if code violations are uncovered, they should be fixed. Because if a seller sells a home with code violations and something happens, the seller has liability, in my opinion. And
yeah,
as well, there is a disclosure statement that's required under mobile home law. You have to still give the same TDS 14 disclosure to your buyer. And if you know of a code violation, you have to disclose it. So, okay, I'm going to have to jump in just maybe one or two more because it's getting really late and I have a 1 o'clock thing I have to be at. So,
okay, Martha, let's take one more and then we'll.
Okay, all right. So the question, Bruce, is can a 1977 mobile home be moved in California?
Can it be moved?
Yes.
Sure. I mean, if you're just asking if I own a home and I want to move it from one park to another park, can I do that? Sure. You have to get a permit to transport it, but sure. If the question is, can the park make a 1977 model, leave the park on resale? I would say maybe. It depends upon whether it's substantially run down or in disrepair, as we've discussed today.
Okay.
Okay.
I want to thank you all for coming here today and thank you for some good questions and some good answers from Bruce. And we'll sign off now. Thank you.
Yeah, very energetic, very valuable session today. Thank you, everybody. It's always a pleasure.